Milord, infructuous.
Dismissed as infructuous.
My appearance may kindly.
Both matters.
Supplementary list for orders item number 2.
Madam, virtual mode. Madam.
Yes.
There is order number 3 dated 8/12/2022. So instead of Anti-Tax Act, it has been mentioned as
The
VAT.
correction is be carried out as indicated. The retyped order be uploaded by in place of the earlier order. All right.
Okay, obliged.
Item number 3.
Item 3, Your Lordship, there is some defects. 1 week time may be allowed to remove the defect, Your Lordship.
Now, what's the delay?
That is, Your Lordship, legible copy and also Orissa annexed, Your Lordship.
Delay.
My Lord,
Delay is there.
What's the explanation of the delay? What is the explanation for the delay?
that is, Your Lordship. Because in my petition for condonation of delay,
COVID. What's the impugned order date? No,
Your
but
Lordship,
the impugned order is 6/11/2019, sir.
19.
Much before COVID. Much before COVID.
my Lord.
By 6th December 2019, the order. This order.
What's the impugned order?
That due to health condition, he was not filed in time, Your Lordship. That I have to.
Prior consent.
So it was not taken. Somebody got paid. There is a delay. The COVID ground is not there in
No.
the condonation petition. It is
No, health, due to health condition, he could not
No,
file.
but the prior consent was not taken. It's a regulation 2 of 56.
that is the
Yes, sir.
merit of the case.
My Lord.
What is the explanation for that?
That
Prior approval not taken for transfer to non-scheduled tribe person.
Yes. That is the finding of both the, that is the finding of all the courts. Your Lordship, that-
Then there's nothing.
Yes, yes. But
the opinion of the all the courts below is that since
Yes.
there is no permission, the
Whole
it is
transaction
ab
is
initio.
void. Correct.
The sale transaction is ab initio.
Your Lordship, maybe one prayer, Your Lordship, may be taken up next week, any date.
For what? There's no need to adjourn it. The present appeal is directed. If delay is condoned, the appeal is directed against an order dated 22nd July 2019, passed by the learned single judge. Sorry, 6th November 2019, passed by the learned single judge, dismissing writ petition civil 219 of 2013, filed by the present petitioner. Paragraph. The present appellant. Paragraph. The appellant in the above writ petition sought the quashing of an order dated 29th August 2011, passed by the sub-collector Baripada in regulation case number 2 of 2008, as well as a subsequent order dated 27th December 2012, passed by the additional district magistrate Mayurbhanj, dismissing the appellant's regulation appeal number 5 of 2010. Paragraph. The appellants purchased the land in question from one Radhakrishna Panda under registered sale deed in 1963 and claimed to be in possession since then. Paragraph. The land originally belonged to a person belonging who was a scheduled tribe, bracket ST. The sale took place, the sale from him to the appellant's vendor, that is Radhakrishna Panda, was effected after the coming into force of Regulation 2 of 1956. Full stop. That sale took place without the mandatory prior permission as required under Regulation 2 of 1956. paragraph. All three forums have concurrently found that the sale transaction between the original owner and Radhakrishna Panda, having taken place without prior permission under Regulation 2 of 1956, was void, ab initio. Full stop. Consequently, no valid title could have been conferred through any of the subsequent sale of the said property. Full stop. With the legal position being clear, no other conclusion could have been drawn by any of the fora below. Full stop. Paragraph. The court is unable to find any ground to interfere with the impugn order and single judge. The writ appeal is dismissed. All right.
Supplementary list health admission, item number 1, ARBP 75 of 2022.
May it please, your lordship, my lords. The arbitration clause, my lords, is at annexure 1, at page, my lords, page 23. Pursuant to an MOU between the parties, it contained an arbitration clause at clause number 15.
All right. You say notice returnable 24th February.
Oh, bless.
Item number 2,
The petitioners, they have filed the case, my lord, challenging the order of the collector, my lord. In the meantime, my lord, they were given threatening that to evict that their premises, my lord. And for that, my lord, the petitioners have filed the RP case for correction of a map, my lord. And that is pending. For which, my lord, I filed the case before this honorable court, and my lord, while he was in vacation charge, my lord, passed the order that I will raise that point before the holder that RP case is pending for the appropriate authority. And in the meantime, I have filed the case for a disposal of the RP case, and accordingly the order was passed also in favor of the petitioners, my lord. While the situation is that such, my lord, now they are going to evict the petitioners, my lord, for which they filed the case before the honorable court. And
What's your instruction?
I think for the past time it is coming.
I see.
It was last before the Honorable
Justice
Justice
Sarangi.
Suddenly, then it was.
All right. Mr. D.K. Mantri, learned additional government advocate, 6 time for instructions. Next Friday?
Yes.
well, in the meantime, they are going to demolish, my lord.
We don't know, sir.
Protection, my lord.
In 1 week, nothing's going to happen.
My lord, the land council may be directed to.
Justice Sarangi heard this in September. All right.
My lord.
Correct? Justice Sarangi
Yes.
heard this matter
My lord.
in September.
My lord.
Did he pass an interim order?
My lord, I had filed the memo for listing of.
No. Did he pass an interim order?
No, he stated that. This
How many
will-
months since the matter was adjourned by him? How many months?
And my lord, I have given memo, my lord, for a
Sir,
listing. My lord,
In 5 months, has anything happened to you?
my lord,
In these 4 months?
we have stated that this case is pending. So
So same thing will get you through, sir. For 4 months you managed, 1 week, suddenly something's going to happen. All right.
item number 3,
May I please, your lordship? Let's file this application for reconsideration of your lordship's order dated 2/12 for the reasons stated in paragraph 5, 6, 7, and 9. May I place those paragraphs, my lords? IA number 33 of 22.
What is the order passed?
So, your lordship has been pleased to appoint an arbitrator.
So that's what, just a participant in the arbitration,
No,
sir.
my lords, here, my lords, the MOU on which, out of which the arbitration clause arises,
I don't think there's a part of review and all in arbitration petitions.
my lords, the difficulty is that I could not bring my counter on record on that day.
Yes.
And there is a point which your lordship requires your lordship's consideration.
Yes.
Because the MOU itself is an inadmissible document. Because it talks about transfer of property from one person to the other.
Please, you can raise in the arbitration, sir. No difficulty. There is a section 16 is there. You can always invoke that. Since the remedy under section 16 of
And
the
it's a-
Arbitration Act is available to the applicant to question the existence of an arbitration agreement,
And
and or
also-
does not consider it appropriate to entertain the present application.
And also, my lords, the agreement being an unstamped one.
Whatever. This will include all other pleas, including the pleas regarding the non-stamping of the agreement. All right.
But it is not required, your lordship, it's on section 7.
You'll argue that all that doesn't have to go here. Sir. The petition is dismissed with the above observations.
Item number 4.
Milords, here, whereas the arbitration clause is at page 201. Milords, I'm sorry.
All right. Notice returnable 24th.
That's, I accept this.
What is your stand? Time for instruction.
Because there is some issue with regard to limitation.
All right. He accepts notice, seeks time for instructions. List on 24th. Limitation all you can raise before the arbitrator, sir. All right.
Item number 5.
Much of this.
Mediation successful.
Yes, one. But however, Milord, on last occasion, the Honorable Council appearing to the petitioner, Milord, he said that the interest amount, the GST amount of rupees 7 lakhs has not been paid. Therefore, Lordship has directed me to take instruction on this matter. But actually, Milord, 7 lakhs because it's the supplier needs to file GST receipt, Milord. And 7 lakhs, however, he has not given us the receipt. So once he files the GST and gives us the receipt, then it will be refunded.
I'm from the petitioner, my lord.
You have proof of paying the GST.
Yes, my lordship, but I have not, that's not shown on the record. I'll bring on the record.
You just give it to him. He says he'll do it.
Yes, my lordship.
The matter has already been settled between the parties in the mediation center. The report of mediation states that MMTC has offered 6% simple interest to the claimant, which has been accepted by the claimant. Paragraph. As regards the GST amount, if the claimant furnishes to MMTC the proof of payment thereof, that also will be refunded to the claimant. No further directions are called for. The petition is disposed of.
Item number 6.
My lords, item 6, we're filing a rejoinder, my lords.
What is the stand at the counter?
My lords, counter, they're saying that since they have initiated similar application section 9 in Patna, here is not maintainable. We have just clarified that that's not correct because one thing, my lords, in Patna's section 9 application, we have not received a notice. Second thing, my lords, our section 9 in Odisha, our suit in Odisha, our complaint case in Odisha, they have appeared enter appearance.
What does the clause say?
Clause, the original, the main clause says, my lords, the exclusive jurisdiction of Bhubaneswar, my lords. There was subsequent clause wherein similar other shareholders were brought on record, where it says Patna or Bhubaneswar, but the original name clause on which the entire agreement
Stands
stands.
for the other side. So what's your, why don't you come this side? You come this side. Why don't you come this side? It'll be easier for him.
Sorry.
Kindly have a glance upon the page 69. There is a specific clause, jurisdiction is either Bhubaneswar or.
So it's either or, sir.
Well,
It's not exclusive.
so the similar matter has been already filed before the request case number 72 of 22, and that is posted to 25th January.
No, when? Just shows us. But no, that's okay. Why should this hold us back? Why should this hold us back?
No, my
You
lord,
withdraw it when it comes in Patna, you withdraw it there. It's only either Bhubaneswar or Patna. The main agreement says exclusively in the jurisdiction of Bhubaneswar.
That's at page 32, my lords.
69 either my
Page
lords.
32, then.
No, 32. Come to page 32.
32. That's the first agreement between the parties, my lords.
The judicial and legal matter jurisdiction will be under the jurisdiction of Bhubaneswar.
That's the first agreement between the parties, my lords. In fact, my lords, their Patna application was filed subsequent to the present application.
Correct.
My lord, may I
The
say,
matter says the distance is not much.
may I pray one thing, my lord? My senior will argue the matter, so kindly adjust. Yeah, 1 week time maybe.
No. You see, the objection taken in the.
We have already
filed by the.
we have already suggested the name of an advocate in my pleading, my lord.
All right. We'll see whoever. What is the claim?
211 crore, my lords. 211 crores,
211 crores.
my lords.
And how you're suggesting an advocate? What is your claim? You have a counterclaim. No, you have a counterclaim.
Well,
Does he have a counterclaim?
No,
Oh, I see. All right. The objection taken by the opposite party to the present petition is that in a subsequent agreement between the parties, bringing on board more shareholders, the clause, the arbitration clause gave a choice of the venue of arbitration being either Patna or Bhubaneswar.
My lords.
Stop. It is stated that pursuant thereto, request case, it's called request case, is it?
my lord.
I
My
see.
lord.
Request case number 72 of 2022 under section 11(6)
My lord.
of the Arbitration Conciliation Act 1996 has been filed in the High Court of Judicature at Patna, in which notice was issued on 23rd November 2022, making it returnable on 25th January. It must be 23.
My lord, 23.
Typing here. We'll stop. Paragraph. Counsel for the petition, on the other hand, draws attention to the arbitration clause in the main agreement between the parties, which reads as under, take from page 32, article 9, bracket jurisdiction. Paragraph. Inasmuch as the above clause is categorical that the jurisdiction would be of the courts at Bhubaneswar, whereas the subsequent agreement between the parties gives a choice between Patna and Bhubaneswar. And further considering that the petitioner invoked the above clause first and filed this petition, whereas the petition of Patna High Court by the opposite party was filed subsequently, the court concludes that the choices of the parties of the place of arbitration being Bhubaneswar, as mentioned in the main agreement between them, should be adhered to. Full stop. That view of the matter, the objection raised by the opposite party to the entertaining of the present application is hereby rejected. Paragraph. As far as the objection on merits is concerned, all pleas in that regard can be raised by the opposite party in the arbitration proceedings. Paragraph. The court appoints, having heard learned counsel of the parties. How about Justice Vineet Saran?
As a lot of service.
The court appoints Justice Vineet Saran as sole arbitrator to adjudicate the disputes with the parties, including their claims and counterclaims. Justice Saran is requested to fix the terms of his terms and conditions. All right. A copy of this order be sent to the learned arbitrator forthwith.
Grateful.
Item number 7.
7, your lordships.
Item 7, you also have sought for instruction. You will kindly allow me 3 weeks time so the file count.
Your lordships, I think the last date when the matter was admitted, Mr. Kashyap was there. And there was a common understanding with the emergency of the situation. Your lordships, we are maintaining a bank guarantee. They have sought to encash it. We have a section 9, we have stay. But your lordships, each day we are bearing the interest over it. Early adjudication is helpful, your lordships, and it's only about an appointment of an arbitrator.
3 weeks time, I'll file the counter.
And they possibly
Already sought for instruction.
Get your instruction or counter, file it in 2 weeks, sir.
lordships.
2 weeks, your lordship.
All right. A last opportunity is granted to the opposite party to file its reply on or before 10th February,
Lordship.
2023. List on 17th
So,
February.
Item number 8.
Millards, item number 8, the reply was supposed to be filed. Instruction. I followed the arbitration clause.
As per the arbitration clause, it's a panel of 3 arbitrators. In fact, they had suggested their nominee arbitrator. Millards gives us 10 days time, we will.
Then we'll finish it. You say counsel for the opposite party points out that the arbitration clause envisages a arbitral tribunal of 3 members. Full stop. He further acknowledges that the petitioner has already nominated its arbitrator. Full stop. He undertakes that the respondent of government of Orissa will, the opposite party government of Orissa will nominate its arbitrator within a period of 10 days from today. Full stop. Paragraph. Thereafter, the 2 nominated arbitrators will meet and appoint third arbitrator within a period of 1 month thereafter. Full stop. If the arbitral tribunal is not constituted in the above terms, it will be open to the petitioner to renew the prayer for appointment of the tribunal. The petition is disposed of.
Millards, just a prayer. If my brother agrees, we can go for a High Court judge. If both of us agree to a particular name.
Yeah, let them, we don't know whom they will nominate. Right.
All right.
Item 9.
9 Millards, it's covered by the Honorable Supreme Court judgment and your Lordship judgment. Relating the circular dated 17/17 Millards, that is on the basis of that arbitrator cannot be appointed. Your Lordship also passed several judgments in that light.
Give him a copy, sir.
I have given already.
Same order.
Only prayer will liberty make and
It's already there.
Liberty is there.
That also.
liberty make and
Yes, yes.
Like,
Special list.
Item 71 not press.
Dismiss is not pressed.
Fresh admission item number 1. CRLMC 1121 of 2016.
None appears dismissed.
Item number 2.
Well, last occasion, Lordship has asked the state government to take instruction whether this freeze would required or not. And another, your Lordship wanted that what is the amount there is in bank. Around 40 lakhs there is in the bank in 3 accounts, my lord. And now, my lord, there is a, I have given those decisions of the Honorable Apex Court where it says, my lord, the 3-4 decisions I have given. One of that Tapos Niyagi, Mahalakshmi Associates. Then the, my lord, the famous case of, my lord, Kanchipuram, that Sankacharya.
Jayanti, sir.
All the, yes, my lord, all the cases, my lord, clearly says that has to be mandatory compliance of 102 subsection 3, which says that immediately after seizure of the, my lord, account, the police officer has to forthwith intimate the magistrate. Here that has not been done. I have subsequent order sheet I have filed of the case, my lord, record. I have annexure 4. The Lordship may see first annexure 1, 2, 3. They have freeze the account on, but they intimated the bank, and the bank intimated us on 14th of November 2016, my lord. And it is incumbent on the, my lord, police officer to intimate the forthwith to the court that they have frozen the account. The Lordship may see the order at page 33 that 18/11/2016 they have not intimated. Thereafter, my lord, 19/11/2016 the date. At page 36, they have not intimated, and 22/11/2016 they have not intimated. On the failure of the mandatory provision, my lord, there is this, my lord, under 2, my lord.
This case
There is
much.
I don't say Lordship.
Here, this case, because the case has been committed to the Court of Sessions and the fag end of the trial was, and only 2 witnesses are to be examined. In this case,
Why should it be attached then? Why should the bank accounts be attached then? The case is not about these bank accounts, sir. Case is something else.
Yes, yes.
That will go on. Why should the bank accounts be attached? That's a simple question. And under what authority of law you attach them?
My lord,
Show us that.
subsection 3 of 102, my lord. every police officer acting under subsection 1 shall forthwith report the seizure of the measures seizure to the magistrate having jurisdiction, and where the property seized is such that it cannot be converted or transported to the court, or where there is difficulty in securing the proper accommodation for the custody of the property, or where the continued retention of the property in the police custody may not be considered necessary for the purpose of investigation. He may not give custody thereof to any person or on his execution bond undertaking to produce the property before the court as and when required, and to give the effect to the further orders of the court to the disposal of the same.
Latest judgment 102. There is a latest judgment also under section 102 CRPC.
Sure.
Because I don't have that judgment just now.
What does it say? So at least you should know that. Simply can't adjourn saying this latest judgment. Somewhere you have to tell us what the judgment is what. Is it contrary? Does it overrule any of the judgments he's citing?
No, so that I have to examine. So of course,
We can pass it over, you find out, you can all find out, Mr. Monty can find it out on his phone.
These judgments still hold the fields, madam.
He may think it's overruled, sir. It may be education to you and to me if it is overruled. Give him the compilation, we pass it over. If any of this is overruled, do tell us. Pass over.
Item number 3. Specialist item number 3.
None appears dismissed. Interim order vacated.
Item number 4.
None appears dismissed. Interim order vacated.
Specialist item number 5.
Same order.
Item number 6.
Same order.
Item 7.
May I please, my lordship? The petitioner challenged the cognizance order dated passed by the London Court below on 27/12/2010 for alleged the commission of offence under section 341, 323, 294, 354, 379, 506, 34 IPC and section 3 of the SC/ST Act. In the meantime, by intervention of local gentries, the matter has been amicably settled, and the OP number 1, the informant entered appearance before my lordship and filed an affidavit indicating then that the matter has, soon after the occurrence, the matter has been settled between the parties. We are pulling well.
All right. Counsel appearing for the complainant refers to the affidavit filed by her in this court, stating that the matter has been settled between the parties and she does not wish to pursue the present case. That view of the matter, the order dated 11th August 2017, order dated 27th December 2010, passed by the JMFC (R Katak) in GR case number 697 of 2010. And all proceedings consequent thereto, orders and proceedings consequent thereto stand hereby quashed. The petition is disposed of.
Item number 8.
Now pending before the Lord and JMFC nearing, my lord, after establishment of a new court. After establishment of a new court at Niyali, now pending in the court of a JMFC Niyali.
All right. All right.
Item 8.
None appears dismissed.
Specialist item 9.
Same order.
Item number 10.
Your Lordship, this is an application challenging cognizance under section 376 of IPC. Your Lordship, the FIR was filed in 2017, making allegation 20 years back of 1997, Your Lordship.
Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is
Obliged.
disposed of. All right.
Item number 11.
None appears dismissed.
Item number 12.
Same order.
Item number 13.
My lord, this matter has already been disposed of by an order dated 8/1/2018.
Show me that order. That's right. Since the matter is already disposed of, it need not be shown again. All right.
Obliged.
Item number 14.
This is the passover matter. None appears dismissed.
Item 15,
None appears dismissed.
item number 16.
May I please? I am challenging the cognizance order taken by the learned JMFC Chandbali. My lord, initially the case was registered under 307, 506 and other alleged offence. Subsequently, it was turned to the 302 and the medical 302, my lord. My lord, the medical report clearly stated that at page number 33 that the deceased was dead.
482, we're not going to.
My lord,
Yes, sir.
the occurrence took place on the 10th of the March and the deceased.
Matter of trial, all this will be matter. Permitting the petitioner to raise all pleas at the appropriate station in the trial court, the petition is
Obliged.
dismissed. Right.
Item number 17,
None appears dismissed.
item number 18.
I've challenged the order of cognizance by the lateral lower court on the ground that there is none of the witnesses have deposed against the present petitioners for the involvement in the alleged offence.
What's the offence under?
Offence under section, my lord, 307, along with other offences.
Then you will get an acquittal for the asking.
No, my lord, what happened? There was a protest for the Mahataship of the Math after the demise of the Mahata. And keeping grudge and with the help of the police, the case has been foisted. And even though my name finds place in the affair, but none of the witnesses examined under section 161 CRPC have disclosed my name.
If you had not got stay by now, you would have got acquitted.
I have already
Created problem for yourself.
stay has been granted, my lord.
Permitting the petitioner to raise all pleas at the appropriate stage in the trial court, the petition is disposed of, the interim order is vacated. Copy of the order be sent to the trial court forthwith. Right.
Item number 19.
Memo taken on record. Dismiss is withdrawn.
Item number 20.
None appears dismissed.
Item number 21.
Same order.
22.
Same order.
22, my lords, I'm appearing through VC, my lords.
Ah.
Item 22, my lords. My lords, here your lordships will see annexure 2, my lords. I'm sorry, my lords, the FIR and everything is in Odia. My lords, I'll just explain the essence to your lordships, my lords.
Yes, yes.
My lords, if your lordship pleases, my lords, then I'll file a translated copy.
No. Your word is good enough for me, sir.
My lords, here, my lords, under annexure 2, my lords.
Yes.
FIR was initially registered on 2010-2015.
Right.
Under section 341, 294, 307, 392, 506, 427 and 34.
Right.
Let's me see annexure 4.
Yes.
Is the charge sheet in which the police officer, after inquiring, declared it to be a false case, my lords.
All right.
And gave the charge sheet, if your lordships will see.
Closure report.
Closure report at page 41.
The complainant filed a protest.
Complainant filed a protest, my lords.
And the magistrate took cognizance.
Magistrate took cognizance, my lords, without examining the complainant and the witnesses under section 200, my lords.
All right.
On the basis of the 161 statement, my lords.
Yes.
My lords may see the annexure 1, my lords.
Yes.
Annexure 1, order dated 5/1/2016, which is impugned, my lords.
Right.
The IO has submitted final form number so and so dated so and so as falls under section 341, 294, 307, 392, 506, 427, 34 IPC against the alleged accused persons. Peruse the case record statement recorded under section 161 CRPC of the available witnesses. The informant Radhesam Jaiswal and other available witnesses, namely Neera Jaiswal.
The minute the eyewitness collapses, everything will collapse. You should allow the eyewitness to speak in the box. By getting stay, you're not allowing that to happen. That's the whole problem.
My lords may see section 200 for a moment, my lords.
Yes, yes.
The word used is shall, my lords.
Yes.
My lords, a magistrate, section 200 of CRPC, my lords.
Yes.
A magistrate taking cognizance of an offence on complaint.
Yes.
Shall examine upon oath the complainant and the witness present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witness.
Yes.
So, he has to take, examine the complainant and the witnesses on oath.
Right.
On the basis of 161 statement, my lords, cognizance cannot be taken since the word used is shall, my lords.
Yes.
My lords, here he has not taken the statement on oath of the complainant and the witnesses, my lords. This entire proceeding is vitiated, my lords. This order is patently illegal, my lords.
What do you say?
Your Lordship, the final form has been submitted,
Yes,
not final report as my learned friend has submitted. The
but it's a
annexure-
closure report, sir. And the complainant filed a protest petition.
Oh, yes, plus the order itself says,
No, only short point is, he says, before taking cognizance, the magistrate should have examined on oath the complainant and the witnesses.
yes, plus.
Has that procedure been followed or not? Is it?
Complaint procedure should have been followed.
You say there is no dispute by the constable of the state that before taking cognizance by the impugned order dated 5th January 2016, the learned SDJM Bonai did not examine on oath the complainant and the witnesses in GR case number 566 of 2015, despite the mandatory requirement under section 200 of the Code of Criminal Procedures 1973 bracket CRPC paragraph. But notice has not gone to the complainant here. You have not issued notice to the complainant yet, sir. Notice now will issue to opposite party number 2 through the SHO of the concerned police station, returnable before the roster bench on 20th March 2023, interim order to continue. All right.
Grateful. My lords, may I only pray name of Mr. Sitikant Misra be deleted, my lords. He has joined government.
I see. All right. The name of Mr. Sitikant Mishra be deleted. All right.
Grateful.
Item number 23.
The petition number 1 was a former MLA. His ground is that because of political vendetta, all this has been raised. So my lord may pass the usual order that in the course of trial.
Constable, the petitioner seeks leave to withdraw the present petition.
No, withdrawal may be.
All right. You say petitioners are permitted to urge all the pleas at the appropriate stage in the trial court. The petition is disposed of.
Yeah, great.
Item 24. 24.
I am for the opposite party.
None appears to the petitioner. Dispense for non-prosecution.
Item number 25.
None appears. Dismiss for non-prosecution.
Item number 26.
Same order.
Item number 27.
Same order.
Item 28.
Same order.
Item number 29.
My please, your lordship. I hear the case, my lord. The petitioner challenging the entire criminal proceeding on the ground that the petitioner at the time of relevant point of time, the inspector in charge of like a police station, and the entire seized amount already released in favor of OP number 2, my lord. And OP number 2 lodged the FIR that on 9/4/2014, my lord, your lordships can turn to page
420.
Yes, my lord. That the already the seized amount of the seized cash already been released in favor of OP number 2.
That's all right.
And your that the BB Agarwal case that the no amount is received and no already no dues have been in favor of the no
That's all.
offense.
That's all.
And your lordships can turn to page 16 that the since it was the election time that the property has been the seizure list of the police officer seized in the cash, my lord. And the cash seized by the police, the IIC, already been released in favor of number 2. Let the notice may be issued in favor of the.
Why should it? You say permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed.
At the time of framing of charge on the.
That's right, at the appropriate stage.
Deep location.
Item number 30.
None appears dismissed.
Item 31.
Permitted to withdraw, raise all the. At the time of charge.
That's right, permitting the petitioner. All right, disposed of.
32.
None appears dismissed.
Item number 33.
None appears dismissed.
Item number 34.
Item 30. May I please, your lordship?
Pardon, lordship. I missed it. Item 30, lordship. I missed that, lordship.
Hmm.
Item 30. I may permit to raise all the point 11 time of time.
30 permitting petition. All right.
Grateful, lordship. Sorry for that.
May I please, your lordship?
30, sir.
Your lordship, I filed this application to quash the domestic violence proceeding, your lordship, initiated against the petitioners, your lordship. Your lordship, kindly see annex 2, your lordship, at page 19, your lordship.
No, there's no, what about the other proceedings are still going on? There must be a divorce proceeding going on.
Yes, your lordship kindly see.
They were all
divorce-
contested proceedings.
Yes, your lordship, mutual divorce has already passed on 1/5/2009, your lordship. 5/5/2009, your lordship, at page 19, your lordship.
All right, it is pointed out that a divorce
Mutual
by
divorce.
mutual consent has already been granted, dissolving the marriage between the petitioner and opposite party number
Your lordship, opposite pattern number 2, your lordship.
2. Is a notice to opposite party number 2, returnable to the roster bench on 6th March. Defects have been removed. Defects we removed in the meanwhile. All right.
Okay.
Item 35.
None appears dismissed.
Item number 36.
My lord, no instruction. No instructions dismissed.
Item 37.
None appears dismissed.
Item number 38.
Same order.
Item number 39.
Memo taken on record. No instructions dismissed.
Item number 40.
None appears dismissed.
Item 41.
None appears dismissed.
Item number 42.
None appears dismissed.
Item number 43.
None appears dismissed.
Item 44.
None appears dismissed.
Item number 45.
My lord, in this case, I have paid to quash the FIR, my lord, but after filing of this petition, a preliminary FIR has been filed. But since then, the final FIR has not, final charge sheet has been not filed. So my lord, I pray, let this case be disposed with a direction for completion of inquiry and filing of final charge sheet within a reasonable short time, because my lord, 6 years past. This petitioner has been made an accused because my lord, only main accused has implicated him. That's why he has been implicated in this case. But he is complete innocent, my lord. 7, 8 years has been passed, my lord. 6, 7 years.
It can't say, sir. This must be what PC Act and those kind of cases.
Let both the cases be disposed of within a
468, 471, sir. 420. We can't say, oh, these kind of cases will take long time.
My lord, only
Permitting the petitioner to raise all pleas at the appropriate stage. That's what they only.
my lord.
All right.
And to expedite the matter, my lord.
That you file a separate petition, sir. Not like this. Yes.
Item 46.
None appears dismissed.
Item number 47.
None appears dismissed.
48.
Same order.
Item number 49.
Lordship, item 49, no instruction.
No instructions dismissed.
Obliged.
Item number 50.
None appears dismissed.
Item 51.
Dismissed as interactions.
Item 52.
None appears dismissed.
Item 53. 53.
None appears dismissed.
Item number 54.
No instruction.
No instruction dismissed.
Item number 55.
Not pressed, my
Not dismissed.
Item number 56.
infructuous, lordship.
Infructuous dismissed.
Item number 57.
None appears dismissed.
Item number 58.
Permitted to raise all the points.
Permitting the petitioner to raise all places.
59 also, sir.
59.
59 same order.
Item number 60.
My lord, item number 60, it is, I accused in custody 7/11/20 and under section 20B2C NDPS Act. And the charge sheet already, charged, my lord, he charged already. And he charge sheet filed on 23/6/21. Sir, how many evidence was examined? I don't know. Kindly they call for the status report of a lower court, my lord.
The first
trial
application
court.
was withdrawn.
Withdrawn, my lord. First application, it is a tied up matter.
Now, what's the status of the trial?
Trial status.
All right. counsel for the state will inform the court of the present status of the trial. List on 17th February.
Mine. Item 61.
I'm for the opposite party. my lord.
None appears for the petitioner dismissal or prosecution. Interim order vacated.
Item 62.
62, I am permitted to withdraw with a liberty to file a better petition.
Why, sir? Raise all pleas at the appropriate stage.
Before the learned JMFC Jajpur
Right.
in GR case
Dismissed
number
as with-
173.
Disposed of is withdrawn with liberty to the petitioner to raise all pleas at the appropriate stage in the trial court.
Item
Interim
number
order vacated.
63.
63 may plead, my lord. The present CLMC has been filed with a prayer to quash the FIR under Annex 12. The allegation is under the offences of IPC of 406, 381, 420, 421 and 468. My lord,
Permitting
What I-
the petitioner to raise all
but I
pleas.
humbly state that there was a stay order, my lord, in the year 2016, and I don't have up-to-date instruction whether
That's
the
all right, sir.
charge sheet has been filed or not.
It's all right, whatever stage it is.
And moreover, the DRCS and the management of the society has recommended the informant, the complainant, to withdraw the FIR. Because
Don't know whether they will or not. We'll have to see. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court.
Oh, bless you.
The interim order is vacated. Right.
Item number 64.
Also, item 64, the matter has been infructuous.
All right. Dismissed as infructuous.
Item 65.
None of it is dismissed.
Item number 66.
Item 66, the noting is there, my lord, opposite party received a.
Well, what's the matter about?
Matter is
District labor officer.
Yes, my lord.
Ah,
That is no instruction, my lord, stays there.
then
there
it's
is
all
no
right.
instruct-
Dismissed as no instructions. Interim order vacated. All right.
Item
No,
67.
Liberty to file an appropriate stage, my lord.
Sorry?
Liberty to file a appropriate stage, my lord, at the time of
No,
charge.
yeah, permitting the petitioner to raise all the pleas at the appropriate stage. That's what I've said. All right.
67.
Not pressed.
Not press dismissed. All right.
Item 68.
None appears dismissed.
Item number 69.
Permitted to raise all the questions.
Permitting the petitioner to raise all pleas at the appropriate stage.
Item number 70.
70, my lord, the initiation of the criminal complaint that is challenge, your lordship. That is vindictive laws, your lordship, that we verified the premises. We found that he was consuming unauthorized power. The provisional assessment was made. And thereafter, final assessment was made under the Electricity Act, your lordship. Thereafter, he filed an application before us for re-verification of his meter. We re-verified. And on verification also found that he is consuming unauthorized by pasting some pasted gum inside the meter, your lordship. Vindictive, thereafter, this complaint petition has been filed against the field staff. They have assaulted.
What is the petitioner? What is his designation? What is he working as?
These are the field staff, your lordship, lineman and meter reader.
No, but what's the allegation?
Allegation that we forcibly enter into the premises and assaulted them. And allegation, your lordship, that is 294, 323, 341, 327, 447, 506 by 34. We have not, the staff, why should they will inside the room?
What's the service report? Have they been served?
The notice was issued, but nobody perhaps entered appearance.
No, you filed the requisites late. Oh, then what happened? 1 minute.
Requisites filed on 3/8/2017, your lordship.
After valid service, it has come back.
My lord. These are vindictively.
Mr. S.S. Rai, who's this?
Mr. Rai.
And Mr. A. Tripathi for opposite party number 2. Earlier one, Mr. S.S. Rai and Mr. A. Tripathi were appearing for opposite party number 2. However, today none appears. In the interest of justice, list move the roster bench on 10th April. Interim order will continue. Registry to inform telephonically Mr. S.S. Rai and Mr. A. Tripathi advocates about the next date of hearing.
Publish.
Item number 72.
My lord, I am appearing to VC your lordship.
Yes.
And I may be permitted to withdraw in the appropriate stage. I may be permitted.
Yes, permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of.
Item 73,
Infractuous, dismisses infractions.
item number 74,
74, my lord. All these petitioners are the staff of forest department. And, the complainant committed theft from the forest department, and for this reason, 2 cases have been filed. Then and there, he filed one complaint case against all the staff, my lord. The yes, my lord. No sanction has been taken, and only on the statement of the initial statement and the statement of some witnesses of his own men that have this case from.
Let it proceed, sir. Investigation is still not over.
Yes, cognizance has been taken, not investigation, that's the complaint case.
Ah, so that's what I'm saying. Inquiry has been ordered.
Cognizance has been taken.
156(3).
Yes, my lord. Cognizance has been taken, my lord.
So all the
Only on the basis of the statements of the own people, my lord.
All right. Permitting the petitioner to raise all pleas, to take all pleas at the appropriate stage in the trial court. The petition is disposed of interim orders.
Your lordships are appearing for the opposite party, my appearance may kindly help.
All right.
item 75,
May I please, Lord? My lord, in this case, my lord, prima facie there is no case made out at all. Your lordship may see the cognizance order without assessing the materials available on the records, without any materials against the present petitioner and the present informant is the not legal married wife of the present petitioner, admittedly in the FIR as well all the documents, my lord. But without assessing the materials available on records, prima facie there is no case made out. Your lordship may kindly see the FIR assuring the informant, the present petitioner, committing sexual acts.
You now the law is well settled, sir. You can now, there's so many case laws. You can cite it before the trial court. You can apply for discharge.
Miller, the petitioner has not married to the informant, my lord, at all.
Raise all the pleas, sir.
No prima facie. Actually, there is no prima facie case is made out against the present
petitioner.
petitioner.
Raise all pleas at the appropriate stage of the trial court. Petition.
At the time of framing of charge, my lord.
Whenever, sir.
Yes.
All right. Interim order vacated. The trial court be informed of the order. All right.
item 76,
Lord, here, my lord, this criminal miscase is directed against an order refusing an application under section 205 of the CRPC, my lord. My lord, a complaint case was filed against the petitioners, and the Lord Magistrate directed for inquiry under section 156(3). And while inquiring, the IO submitted final report. And after submission of final report, again the Lord Magistrate has taken cognizance. So when he took cognizance, my lord, the petitioner number 1 is a government servant, my lord, and other petitioners are ladies, and some petitioners are all students. They all of them belong to one family, and they filed a petition that under section 205 of the CRPC. But the Lord Magistrate has rejected the same on the ground that no documentary evidence has been filed to substantiate the submission. That is the sole ground of rejection. Lord, normally in this, this is arises.
You got the entire proceeding state, sir. That's very unfortunate. And you're only 50 years old. You're not some old person. Even petition number 7 is 60. Nobody's an old person here.
No,
who's the old person?
One is 50 years. He is a government servant, my lord, a teacher.
How is they are not old person, sir?
My lord, one is a teacher, one is a student, and all and there are other lady members, my lord. Petition number 6 is a lady. Petition number 2 is a lady, my lord.
You say the petitioners will appear before the SDJM Bhadrak in ICC number 100 of 2016 on.
More probably that arises out of a civil dispute also, my lord, pertaining to a road.
On 2nd March 2023 and seek exemption from appearance thereafter by filing appropriate applications, which will be considered in accordance with law by the said court. The court clarifies it is not expressed anywhere in the matter. The interim order is vacated, the petition is disposed of.
Item 77,
Memo taken on record, dismisses withdrawn. Stay vacated.
item number 78,
May I please, Lordship? Lordship, on noting that our counter was not solved to us.
Solid, what's the matter about?
Lordship, actually, we can able to trace the file to let them
Then
solve the
we'll-
counter. Will
No. Counsel petitioner states the file cannot be traced in his office. Dismissed for non-prosecution, liberty to the petitioner to revive the petition as and when the file is traced. Copy of the order be sent to the concerned court. Interim order is vacated and petition is dismissed.
item 79. 79,
None appears dismissed.
item number 80,
May I please, your Lordship? That petitioner challenging the order of cognizance is for offence under section 130(10)I Act. Notice was issued to the complainant.
This is a settlement, you take all the pleas at the appropriate stage.
Lordship, but it's a case that check was, it is a petitioner is the marfadar of the DT property and he forced when the land acquisition amount was lying in the bank, the opposite party with malafide intention forced the petitioner with the priest to give a check. That is the case.
5 lakhs check.
And that is a pardon?
5 lakhs check.
5 lakhs check, and case is that is like notice was issued and there was a stay of further proceedings. So far, complaint is not coming to this before Lordship.
Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of interim order vacated. Right.
item 81,
81, your Lordship permitted to withdraw with an liberty to withstand all the points.
Permitting the petitioner to raise all pleas. All right.
Obliged, Lordship.
item 82,
Memo taken on record, dismisses withdrawn. Interim order vacated.
item number 83,
In this case, the petitioner tries to quash the FIR matter. FIR filed by the wife matter. In the meantime, the wife and husband have compromised. Annexure 3 matter. By mutual, they have divorced and accordingly the permanent alimony has been given.
Decree of divorce by mutual consent dated 8th August 2017 is enclosed as Annexure 3. Counsel appearing for the complainant confirms this fact. That view of the matter. FIR number 100 bracket S, is it?
Yes, ma'am.
100 bracket 3 dated 1st September 2013 in PS Narsingpur.
Yes.
And all proceedings consequent thereto are hereby quashed. The petition is disposed of.
item number 84,
Item 84, my lord, the charge sheet has been submitted as per my instruction, my lord, I have been exonerated. So last occasion, the honorable court directed to open
Submitted on 304A. And also this person's name doesn't find place in the final.
charge sheet, ma'am.
In the final court.
I am the treating doctor, my lord. The allegation that, my lord, the deceased made an accident and he was brought to the hospital and I treated him and I referred to the Bulla hospital. Since he asked for the ambulance is not provided. I am the treating doctor. So I have no way connected. The charge sheet has been submitted and I have been exonerated.
Final formula submitted under 304A. That is
304A, man.
only against one person. You also can tell that.
No, so he's exonerated.
Yes, this person has been.
Then we dispose it out.
My lord.
It's confirmed that the petition has been exonerated in the department proceedings.
No. After the investigation, the charge sheet has submitted.
He stands exonerated since it's not named in the charge sheet filed. Full stop. In that view, the matter, the petition is infructuous and is disposed of as such. All right.
item number 85,
None appears disposed.
item number 86,
86. In this case, the initial, the opposite petition number 2 filed FIR matter, that is annexure 2 matter. On that, on the counterblast to that case matter, the opposite one to file a complaint case, that is annexure 1 matter. The long magistrate have taken cognizance of annexure 3 matter. For offence, the silly offence 506 and 294, 223, or 34 IPC, my lord. There is a, counter, that is the counterblast of the.
What happened in your case?
My lord?
Your FIR, what happened?
In my,
Your FIR against the other party, what happened?
that is, I don't know what is the status of the case.
Permitting the petitioner to raise all pleas at the appropriate stage, the petition is.
At the time of framing of charge, the lordship.
Yeah, interim orders vacate.
Item 87.
My lord, I am for the opposite party number 2.
Just
My appearance may kindly be required.
Yes, yes.
Item 87.
You're for the opposite party. I'm for the opposite.
University, my lord. I was an engineering student, my lord. Unfortunately, I entered into the website of the university. The allegation is page 7. Consequent upon which I am still jobless, but that is another matter, my lord. I got a job, could not get the passport, though your lordship directed, they considered. Your lordship may place that page 7.
Yes.
I am directed to inform you that the official website of Orissa University of Agriculture and Technology, such and such, has been hacked on 15/1/2016 at about 7 p.m. On getting information from the authority, immediate action has been taken by disabling the website at our end. In this connection, I would therefore request you to please conduct a thorough investigation in this matter.
The charge sheet filed or not filed?
Not yet, my lord.
So you let it be filed, sir.
Section 65, 66C, my lord. 66, 66A is gone.
Gone.
So may I place those sections, whatever your lordship directs?
No, you urge all the pleas, sir. Permitting
My
the
lord,
petitioner to urge all.
why
the
I am
pleas.
before your lordship, reason being, my lord, primarily, and I don't think my learned friend will object. No loss has been caused to them.
No, this is serious, sir. Hacking a website is very serious.
It's my lord, my problem is, my lord, I am a student, my lord. I am a specialist in ethical hacking with cyber security. I was doing that.
White hat hacker.
It's not a question of hacking. I am not called any law.
White hat hackers.
Your lordship may kindly look at the provisions. My lord is aware of. Just a moment, my lord.
Yes.
Why should the FIR be quashed? In the course of investigation, whatever comes out.
Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is at the appropriate stage, you say, the petition is disposed of.
संदीप मैं बस पूछ रहा हूँ ये जो जीएसटी में हम मांग रहे हैं इसका हम बिल रेज कर सकते हैं
Hello.
All right.
Item number 88.
None appears dismissed.
Item number 89.
I am appearing through BC.
Yes.
And permitted to withdraw.
All right. Permitting the petitioner to raise all pleas at the appropriate stage. All the matters.
Item number 90.
May lordship. Here, my lord, petitioner is in custody since 28/10/2020, my lord. An offence under section 302, 201 and 34 IPC, my lord. In the meantime,
Start time for instructions.
There's no antecedents, so but that instruction I have received.
All right. How many years have you spent?
he is 28/10/2022. 20, my lord. He is in custody.
Commitment.
No, charge sheet filed, my lord. Committed, and in the meantime, out of 32 witnesses, 12 witnesses has been examined, my lord.
No, which are these? This is a circumstantial evidence or?
Yes. Actual fact is that there is a UD case was registered on 14th.
No. I think this is a direct evidence case, sir.
No.
Chance witnesses are there.
Yes, there is a chance witness, but here the petitioner is not the principal accused, my lord.
No, but there's direct evidence. All these witnesses have been examined.
No. 32 witness, only 12 witnesses examined. We provide 6 deposition copy of 6 witnesses.
Which of the chance witnesses have they been examined or not?
Out of there is rejection order there. 3 witnesses, chance witnesses have been examined, my lord.
Can you find out what the trial stage is?
Yes,
Mr. Katkias needs time to find out the current status of the trial at his request list on 3rd February.
In
Pastor matter item number 2.
Plus, there the judgment which has been relied upon by my learned friend, plus also has been dealt with by the Honorable Allahabad High Court in a recent judgment, my lord. And they are relying upon another judgment of the Supreme Court, which has been delivered by 3 judges bench, my lord. It is a division by judgment, the 3 judges judgment, and whatever proposition is being advanced by my lord, that is against that proposition. That means if it has not been reported, if the seizure has not been reported to the magistrate, that doesn't vitiate the proceeding. That doesn't vitiate.
No, but this whole procedure for seizure, did you take out a warrant or not?
As because it's a very latest judgment, so I want that. So let me verify the position of law.
All right. While counsel for the Mr. Payal, senior as learned counsel for the petitioner, relies on the judgments in State of Maharashtra versus Tapas Niyogi, 1999, 7 SEC 685.
And that judgment has also been reported.
Sabarwal versus Commissioner of Police, 1990, 68, company cases 52. And urges that this freezing of the bank accounts contrary to section 102 of the CRPC is unsustainable in law. Learned Mr. Katke, learned AG, seeks time to place certain other judgments which according to him hold against the petitioner at his request list on 3rd February. All right. One we
just disposed of, saying that the petitioner will submit the GST bills and they will release the payment as accordingly.
Yes.
My lords, just need a small direction, my lords, if you may permit that it may be done in time-bound manner of because again it will drag.
Proof of GST bills is submitted within 3 weeks. Then the payment will be made within a further period of 4 weeks thereafter. All right.
Oblige, my lords.
RBW PET 250 of 2020.
I'm not, may I please your lordship?
Yes, please.
Yeah, I am appealing for the petitioners here.
Yes.
Let's have challenged the order passed at page 155 in WPC number 14435 of 2019.
Right.
Millards, at the stage of admission, this was disposed of relying on, Lordship may kindly see as the paragraph 3. On perusal of the records, it appears that Special Land Acquisition Officer, MCL, by order dated past investigation, which quoted on that basis you are disposed of. We have challenged this order in another writ application which is pending before this honorable court. Because and we were never heard. Your Lordship may kindly see.
But how can you challenge a judicial order in a writ petition?
No, not this order. The order of the Special Land Acquisition Officer, on the basis of which this application has been disposed of, has been challenged by ourselves in another writ application.
Mr. Das, is there any delay because you have filed an application for?
Yes, Millards. Delay, Millards. The delay is because the file was entrusted to Mr. B.M. Patnaik.
No, it's all right, but notice, but perhaps not been issued in that.
No, notice has not been issued.
No. What's the delay?
Millards, the delay is. There is a delay, Millards, because after it came to our knowledge, we filed this.
So we can clarify this will not create a precedent. I think that is
the whole difficulty is he is now demanding employment on the basis of this order. Facts
it's all right, only one person. Only one person, sir.
No,
not create a precedent.
Millards, there is one man, Millards, has 3 sons. 2 sons have been given service on the basis of acquisition of land. The third son was adopted.
Mr. Das, that is a temporary one. Only one member has been given. Those appointments, 2 persons were temporary one. And
no, Millards, they are permanent one. They are permanent one. Millards, because the land of the present petitioner, Nilamani, was acquired, he had 3 sons. One son has been adopted away. His title is Biswala. Now, Purno Biswala, he was adopted to Purno Biswala. His third son got appointment as the son of.
We'll clarify, it will not create a precedent, sir. These are not matters where we should now interfere.
No, difficulty will be, Millards, even if your Lordship clarifies, he will demand that I must get a job.
No, that you have to comply with the order. We're only saying it won't create a precedent. We're not excusing you from complying with the order.
No, complying means we have to comply means this order cannot be complied. He is forced. He has made the person who has been adopted away to another family. He has got an employment as the child of another family. Now his son, whose title is Biswala, his original grandfather claiming to give him appointment as my grandson. So this is the problem, Millards.
Mr. Das, the other 2 persons who I'm stating, please come to page number 4. It is stated that they were given temporary appointment for 5 months. So
thereafter they have been made permanent, Millards.
That is up to you. You have chosen to make them permanent. That's different.
No, Millards, this fellow is not a son of the present. Nowhere now connected with the present.
2006, their entire thing was taken away. Only 1 person has been.
No, 2 persons have been given appointment.
No, that is temporary. You gave permanent. But
as a land house,
the order was temporary. Please see your agreement is also that.
Conditional appointment. This is conditional appointment.
That is for 5 months only.
No,
page 4. Page 4, please come to that. Page 4, clearly it is mentioned. That is terms and condition. That is mentioned that Girish Sahu and Gopabandhu Sahu are given temporary appointment for 5 months.
Till handing over the land, Millards.
All right.
They have now handed over the land and they have become permanent.
All right. There is a delay of 119 days in filing the review petition. And
your Lordship may kindly observe my difficulty will be. Your Lordship may give me 1 minute, I will explain. Millards, Nilamani Sahu has 3 sons. 2 sons have been given appointment as land houses. They were given temporary after the land was taken over, handed their houses. The third son was adopted to another family as a person, namely Purno. He is Purno Biswala. He is Nilamani Sahu. As Purno Biswala, he was adopted. He has been given employment under MCL as the land house of Purno. Now the grandson of Purno's son, who is Biswala, this Nilamani Sahu wants to give him appointment as his grandson. Annexure 5 at page 48. Millards may kindly see. Kindly see. He is Bipin Biswala. Son
Mr.
of
Das,
Purna.
Mahanadi Coalfield is unable to give appointment to only one person.
Millers, now it is
What are you
difficult,
telling
Millers.
me?
Now it is difficult, Millers.
All right.
Otherwise, I would not have come.
All right.
I have. There is a difficulty, Millers. There are so many land oustage. We are in difficulty.
All right.
Your Lordship may kindly issue notice, Millers. It will
No,
be
no.
clarified.
No. We're not inclined to.
Otherwise, Millers, then your Lordship, he cannot claim as a land oustage of the petitioner, as a child of petitioner.
No, we're only saying it will not be a precedent. You say there's a delay of 119 days in filing the present review petition, and the reason offered is purely on administrative grounds, which have not been accepted by the Supreme Court in a series of judgments, including Living Media and Berula paragraph. Nevertheless, on account of the persuasion of Mr. Shaktidhar Das, learned senior counsel for the MCL, which is the review petitioner, the court has also examined the petition on merits and does not find sufficient grounds to recall or review the order dated 4th February 2020. Nevertheless, the court clarifies that the said order was passed in the peculiar facts of the case and will not be treated as a precedent. The review petition is dismissed with the above observations.
We are never hard in the case. That is our grievance.
All right.
It is an ex parte order.
Right. Namaskar, sir.
Namaskar, sir.
Supplementary list for order.
Pardon
Item
to
number
make one mention, Your Lordship. The writ petition was dismissed by Honorable Justice Jhaveri and Justice K.R. Mahapatra, Your Lordship. Thereafter, review petition was filed, but the review could not be taken up, Your Lordship, since 2019.
Right.
So I'm mentioning the review petition, Your Lordship.
Next Friday. We have
I have also more than 10 cases review petition. Your Lordship and Justice K.R. Mahapatra.
All right.
I have
Next
I will
Friday.
mention.
Next Friday. Whatever you give the slips and next Friday.
This matter will be taken up today.
Yes.
Item number 1.
This is a matter for assessment year 1991, and the assessee made a claim of rupees 15,20,871 as an interest paid for the years 83-84 to 89-90. The reason was the assessee has borrowed money from the bank and was paying the money as a interest and deducted before 83.
Which application is this?
Your Lordship, there is a
Say your argument.
IA.
IA. Which application is this?
I have given a note to Your Lordship. IA number
2 of 22.
2 of 22. 20. No, 20 minutes.
2 of 20.
Yes. IA number 2 of 20.
How does this survive?
Because Your Lordship had passed an order, because my claim was that if it is not allowable in this year, the other previous year should have been allowed, because I cited 2 judgments with Your Lordship. Your Lordship passed an order where it
No, look at the prayer in this application, sir.
Yes.
Page 5.
Sir,
Prayer in this application.
Please look at the prayer.
I'm-
Prayer in the IA, sir.
Yes, just for extension of period only.
That's all.
No,
That's
that
all
has
over
been
now.
allowed. That has been allowed.
We are already allowed, sir.
That is, but
1/8/2020.
the first the petition has, the order has not been correct. 1 of 220. 1 of 220, 2020, Your Lordship has given for access financial year 89-90 and 90-91. But I came to correct the financial year to be read as.
All right. He wants the sandwiching of 89-90. That can be allowed.
That can be done.
All right. In IA 1 of 2020, the prayer of the petitioner that the order dated 4/12/2019 should be modified by including the year 1989-90 is hereby allowed. All right, the application is disposed of.
Great.
Anything else, sir?
No,
To
that's.
2020, you say this application does not survive any longer and is disposed of.
No, your lordship have already given the time, extension of time.
That's right. Therefore, it does not survive, sir.
That's right.
Yes.
1st March.
All right. All right. That's it, sir. Okay.
Grateful.
Oh, there's one more matter. Sorry.
Item number 2.
My lord, here the demand is more than 4 crores 39 lakhs and has been withdrawn on the circular 50 lakhs. May be revived and the identity matter has been fixed on 20th February 2023.
All right. You say it is now pointed out in the present application that the tax effect is more than the monetary limit. In that view of the matter, the order dated 16 November 2018 is hereby reviewed. And the review petition is, the IA is reviewed and recalled. Full stop, the IA is accordingly allowed. And in the main appeal, you say this appeal stands restored by virtue of the order passed today. In IA number 11 of 2020.
11 of 2020.
2020. Full stop. List along with
20, along with so many cases 71 2018 73 72
just give one number, sir.
Anyone 164 2018
ITA 164 of 2018 on
20 February 2023
20 February
20.
Okay, 20th February. All right. All right. Right, sir. Thank you. MS Sahul. Hi, Pranam, sir. Pranam.
Supplementary list for admission, item number 1.
My here with your lordship's kind permission, on the last day, the lord paragraph. In fact, the ACs are very cold.
I see. Switch off the AC. Ask him to switch it off.
That's really.
No, please. This weather, you don't need ACs.
Both my friend and myself are not able to go.
No, you should have told us. We could have switched it off. That's it.
Now here your lordship wanted to know, pursuant to the observation of my Lord Justice Mahapatra, your lordship wanted to know whether they can have an expert agency to assess. That, my lord, in my
safety auditors, Mr. Mishra.
My lord, I stand corrected. That is also subject to the other part, namely, your lordship had also suggested whether they can bypass and whether the action from the inception is in accordance with law. If it is not there, that has to go. But now the affidavit has come where they have only approached the authorities. They have not yet finalized, because your lordship will peruse the affidavit, page 2, paragraph 5, 6, the affidavit copy of which has been given to me.
Submitted an online application. Right.
And they say they will rope in Moody International Private Limited.
All right.
But that has been finalized. There is nothing.
May I place my affidavit?
I'm sorry.
May I place my affidavit? This was filed at Flag F, my lords. I have filed pursuant to order dated 9th December. So essentially, my lords wanted to know regarding the agency that would conduct the inspection.
Correct.
And the schedule for the same, so that my lords could pass appropriate orders.
Right.
So my lord, accordingly, this affidavit has been filed at Flag F.
Right.
So the agency that is here, that is the Petroleum and Explosive Safety Organization.
Right.
Essentially, the statutory authority is the Chief Controller of Explosives.
Right.
And this inspection is under the petroleum rules.
Right.
And online application has been filed on 11th January.
Right.
Simultaneously, my lords, an internal audit is being conducted by a PNGRB empaneled auditor, Moody International. Now, once the report is available, the internal audit report is available, and compliances are corrective steps wherever necessary will be done, and then the GAIL will approach the the Chief Controller of Explosive for the inspection. So that is the schedule. Once the report is available, then the date for inspection will be fixed by PESO. That is the Petroleum and Explosive Safety Organization.
So we can ask that same organization to take into account any note that they submit
That is
expressing their concern.
That is one part of it. But let me just humbly clarify one thing. This is what your lordship wanted to know to decide whether any further review is justified or not. So therefore, let them submit the report. Then your lordship will find out, because from the inception, this is not a private road. This is the internal road given by the builder whosoever has sold to the concerned landowners, and they have taken a pipeline in the internal road even without a notice, your lordship, on the face of record. That will be on merit of the case. So therefore, after they submit the report, my lord, before your lordship will again decide the issue related to that. Well, otherwise, your lordship will find what will happen. This is just like, my lord, they not adhering to the rules, then saying that we will regularize because there is a safety report. That is the thing. Your lordship will see on the face of it, my lord, they have not, my lord, even served a notice, my lord. Because the statute mandate.
More than heard, sir. In these proceedings, so many affidavits.
Affidavits. What they are trying to say.
May have been heard. I don't think you would have been heard this much at that stage.
I have no grievance regarding that. I am grateful, my lord. The only thing I beg to point out to your lordship is, my lord, they cannot say that we will regularize it, an act which is from the inception not illegal. And your lordship also suggested whether they can take it in some other route. That also, my lord, they said that no, we cannot.
If it's unsafe, then that question arises. If it is not unsafe, then the question will not arise. So that the PESO will decide that. All right.
That is there, my lord, but only this part your lordship will consider. There is absolutely no notice on the face of it.
You see, in an affidavit filed on 13th January 2023, GAIL India Limited has explained that the Petroleum and Explosives Safety Organization, (PESO), will conduct statutory inspection and certify the pipeline in question for commissioning. Full stop. PESO is stated to be headed by the Chief Controller of Explosives. Full stop. While it has an head office at Nagpur, it has an office in Bhubaneswar headed by the Deputy Chief Controller of Explosives, (DCCE). It is stated that on 11th January 2023, GAIL India Limited has submitted an online application to the CCE, PESO. Full stop. It is stated to be simultaneously conducting an inspection of the Dhamra, Angul, and Bhubaneswar Cuttack spur pipelines, which are the subject matter of the present proceedings, through Moody International Private Limited, MIPL, which is a third-party inspection agency empaneled by the Petroleum and Natural Gas Regulatory Board of India. Full stop. It is stated that MIPL will examine the technical standards and specifications, including safety, of the pipelines, and submit its report to GAIL India Limited to facilitate the inspection to be conducted by PESO. Full stop. GAIL India Limited states that after examining the report of MIPL, it will take the corrective steps wherever necessary, and thereafter approach the office of the DCCE at Bhubaneswar for site inspection. Full stop. It is assured that only after PESO issues a clearance for commissioning of the pipelines, provided the pipelines meet the requisite and technical safety standards, will the said pipeline be operationalized. Paragraph. In view of the above assurances, which the court takes on record, it is not felt necessary at this stage for the court to recall its earlier order dated 15th December 2021. But it is clarified that the above assurances of GAIL India Private Limited will be read as part of the said order. Full stop. It is further clarified that both MIPL and PESO will, before finalizing their respective reports, take into account the note which will be submitted by the review petitioners to GAIL India Private Limited, on the safety aspect of the pipeline and the appropriateness of its location in that context, within 10 days. We will submit a note to them within 10 days.
Within 10.
May I interfere here? My lord, Moody International has completed its internal.
All right, to PESO, you say. Then you will, PESO will be before finalizing its report. All right.
And depending on the outcome of, suppose the report is adverse, then the pipeline has to go.
Yes, yes. It's needless to state that if the report of the PESO does not recommend commissioning the pipeline, it will not be so commissioned.
Grateful, my lord.
Grateful.
The review petition is disposed of the above terms.
My lord, for opinion number 1, where there Mr. Mahanti for opinion number 2, along with
All
Mr.
right. All right, sir.
Raiguru is appearing his name.
All right. All right. 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 Namaskar, sir.
Supplementary list for orders, item number 1, CMAPL 550 of 2022.
The writ appeal has been dismissed for non-prosecution, filing the CMPL for restoration of the, because of traffic jam, the advocate for the appellant could not reach at time.
What's the matter about main matter?
Main matter, my lord, order of single judge has been challenged, and that has been stated by this honorable court.
What is the matter about, sir?
The my lord, as outing some. Has allowed the repetition and to pay some compensation to the opposite parties. Opposite party now, opposite party, we have a substitution, opposite party.
No, it's about some promotion, sir.
No, my lord, not promotion. That is appointment of the petitioner, disengagement of the petitioner.
No, no, come to ground C.
My lord?
Ground C. In the writ appeal?
Yes, my lord. Round 3.
C. Writ appeal 410 of 2022. What are you appearing in?
No, that is 202. 202 2015.
Oh, sorry.
202 Umakanta Pradhan, my lord.
All right. Sorry, sir.
This is office order, right? 202.
All right, for the reasons stated therein, the CM appeal is allowed. 26 September 2020 is recalled, and writ appeal 202 of 2015 is restored to file. In that main writ appeal, this has been restored today by a separate order in CM appeal. List before the roster bench on 28th February.
Item number 2.
Item 2, in paragraph 3, in third line, it has been typed as WPC number 863 in place of WPC number 38,636 of 20.
All right, the correction we carried out as pointed out.
Some prayer you and in that order, your lordship is directed to list the matter before Honorable Single Bench on 5th December, and the writ has, and you are also directed to requested the Honorable Single Bench to dispose of the writ within a period of 4 months. That may be extended, man.
Why? That will still continue, sir.
But your lordship directed the writ be listed due to this historical mistake. The writ could not be listed till late, my lord. Your lordship directed the writ be listed on 5th December. That period has gone, my lord.
But it is not listed.
All right, the said writ petition will now be listed for directions on 6th February.
My lord.
Right.
A pleasure.
All right. Right.